We have yet to release any kind of binding legislation or regulation on generative AI. And that leaves a lot of ambiguity, both for users and for companies in the US. And Silicon Valley companies are taking advantage of that ambiguity for sure.
What are the key differences in how the US and China handle court cases relating to AI?
The way that AI disputes are playing out in Chinese and American courts is, I think, really indicative of the broader global debates about AI, what it's going to be, that it might destroy us, that it might make everything better. These are the large so-called hype narratives that are coming from CEOs like Sam Altman, who are very much playing into the goal of attaining AGI, what they call artificial general intelligence, which is going to save us from cancer and climate change or kill us. And we just got to kind of roll those dice. So those are the grand narratives that are the backdrop of very in the now present issues concerning specifically intellectual property and the way that it was used to train AI generated products such as OpenAI's ChatGPT, but also a bunch of other generative AI tools that exist in China as well. And then also on the flip side, the way that users can or cannot attain intellectual property rights for creations that they make using these generative AI tools. So what I like about intellectual property as an issue to focus on is that it both grounds us in what's happening right now, when so much of the discourse on AI is future oriented and cannot be empirically backed per se, and also has tons of challenges in terms of compute capacity, climate change repercussions, and other concerns that many people are doing the great work of pointing out regularly. And it really situates us in the present and focuses on harms that writers and other content creators are hoping to have addressed in terms of how their work was used to train the models. And also for artists and creators who are looking to use these tools now, but want to have the assurance that their work will be protected. So it's really a two-sided issue. And conveniently, the Chinese and American courts are each taking on one of those sides for the most part, with US cases primarily focused on that input side. And so you have big cases such as the New York Times suing OpenAI over its use of New York Times content. And, as a backdrop to that, there's other American news outlets who are making deals with big AI companies to provide consent for using that content, since they've basically calculated it's going to happen either way, because there's not a national regulation that would bar it or a law that would make it illegal. And then in China, the cases have been more focused on outputs and on intellectual property protections for users who create art and other products using generative AI tools. And basically the degree to which the human issue of creativity and modification comes in to sufficiently make a work that users, rather than just a product that was created with the AI tool. In both countries, it is content creators of various kinds who are bringing the cases. So, for example, you had the actor and comedian Sarah Silverman bring a case in the US. She was concerned about the way that her book was used and her other content was used. And in China, you have individual artists, potentially not even professional artists, but people who are creative in their own right. For example, there was a case where a user used Stable Diffusion, which is somewhat ironically a US-made tool, to create an image that he modified, put his own kind of touch on, and then he put a watermark on it to protect it. And another user on social media reposted that image without his permission and without crediting him having removed the watermark. So he brought that case forward. And so this really is rooted in individuals who are seeing how IP, lack of clarity, how ambiguity surrounding IP and AI can affect them directly right now. So again, I like that it's very grounded in current disputes and in real life interactions between humans and AI, rather than placed in this far off hypothetical narrative. To bring a case, a plaintiff needs a set of facts. A plaintiff needs to have a description of harms incurred, not potential harms that might occur in the future. There are a few exceptions to that, but for the most part, in order to have a real case, you need to be able to come forward with an experience. And so far, nobody that I know of has had their life utterly saved by the concept of AGI. And on the flip side, these comparatively smaller level disputes concerning IP are happening in real life and are playing out in both the US and China. I think that one maybe side benefit from these grand narratives that CEOs enjoy in Silicon Valley and to a lesser degree in China is that comparatively, your IP does not seem very important if what we're up against is robot armies or existential threats or huge benefits for humanity, right? If that's what they're saying is on the table, then whether or not you can put a watermark on an AI generated image seems really beside the point. So that allows them to sort of get away with fast forwarding past these inconvenient issues of IP. And the two countries' legal systems are set up in ways that very distinctly can come in and play a role to try to right some of those wrongs, not necessarily in real time, but in the near future after the harms were incurred rather than in hypothetical land far, far into the future.
How are the US and China using AI tools? Do you see differences in how users or companies are developing these AI tools in different sectors?
Well, the major difference that does get a lot of airtime for good reason is AI firms in China have to confront a much more restrictive information environment. They have to operate following the existing guidelines for cyberspace that are overseen by the CAC, Cyberspace Administration of China. And they are held to a very high standard in terms of not introducing new forms of information chaos with advancements such as generative AI. So they are up against a bit more challenging of a background environment than the relative Wild West of the US, where content is king. So that's a major difference, and that has affected both users and companies. But I would say that another major difference is China's a bit faster at coming up with tech-related regulations that may or may not have a direct relationship to the censorship regime and stability maintenance more generally. But the fact of the matter is China has a data privacy law. It has clear generative AI regulations that were promulgated a year ago. We have yet to release any kind of binding legislation or regulation on generative AI. And that leaves a lot of ambiguity, both for users and for companies in the US. And Silicon Valley companies are taking advantage of that ambiguity for sure.
What are the areas for cooperation in AI between the US and China?
I like the concept of intellectual property best practice sharing as an area for potential cooperation between the US and China. I have to provide the caveat of it's potentially very unlikely just because many things in the relationship are difficult to achieve these days. But what I like about it is sort of playing into both countries' interest in national security or securitizing the space of generative AI, making sure, for example, dangerous misinformation doesn't run rampant. It plays into that regulatory structural security-oriented goal, which both countries do have in very different ways. And it also is boring enough that bringing together nerdy experts in intellectual property from both countries to really work through some of the nitty-gritty issues, hopefully bringing to the table each home country's experience working IP disputes out in the courts on the input or output side seems really possible because it's not inherently wrapped up in the issues of censorship on the Chinese side or on tech competition per se. Both countries want their people to have access to clear intellectual property rights. They want them to be able to access that despite the emergence of generative AI, even if it's just because they want to encourage the use of these products. which both countries do because both countries want to have a very significant, sizable, powerful AI industry. Judge Ge of the Beijing Internet Court said as much in a public appearance she made at the beginning of this year, when in describing a ruling that they made that was read as quite pro-industry. She said, yeah, I mean, we want people to use these products. We want to develop the industry. That is a clear priority. We're seeing more recently signs of that. Earlier this week, the director of this CAC said publicly that development is a clear goal, that he called out intellectual property as an area that needs to be strengthened in order to foster that development, but also to maintain security in both generative AI specifically and in cyberspace more generally. So I think it's an area where there's sufficient mutual interest, and it isn't necessarily as rife with some of those background competitive rivalry-based issues at the core of the U.S. China relationship.